As we did the first meeting, I want to make sure everyone understands that this is a public session. It's being live streamed as well. You can find the live stream on the Supreme Court's YouTube site as well. There is a website that we have posted at the Vermont Supreme Court. Go to vermontjudiciary.org, vermontjudiciary.org, and that's how you'll find it. The website will have PowerPoint presentations that these good folks have made, and other materials I expect as well. Please mute your microphones if you're not speaking, but if you do want to ask a question, Sarah and David have made it very clear that they're very happy for you to interrupt them during their presentation. We're on WebEx here this morning, and there is a function next to your name to raise your hand. And that's okay if you want to do it that way, but it may be that I will not see it right away, which is why we want to make it clear that we're happy if you just interrupt the speaker with your question. This is a process that I think everybody is comfortable with, so please feel free to do that. We will take a break, one break, about 11 o'clock, about 11 a.m. You know, it's funny because if we were meeting in person in the courtroom at the Vermont Supreme Court, I would have given you all some directions on how to find the restrooms in the building, and water and coffee. In that each of you are self-sustaining in all these measures, then it's really up to you to take care of yourself in your own households or your offices, wherever you may be. Let me see if I've got anything else that we're gonna, the meeting will end around noon. I think I've covered everything I wanted to. Anyone have any questions? Okay, then I'd like to go through, I have on my screen, as all of you are able to implement on your own screens, a list of participants. And what my plan is simply to go down the list, and I'd ask you each, when I call out your name or your phone number, if we have people who are phoning in without names. I don't see any, but if that happens, I'll call out the phone number. Please just identify yourself, what agency or branch of government you're here on behalf of. That's all, and we'll move on to the next person. Again, I want to thank each of you for your participation in this process. So good morning again, and Sam Griffith. Oh, Sam, you're the host. Sam, introduce yourself, will you please? Tell them who you are.
Hi, folks. I'm Sam Griffith. I work for the judiciary as an operations assistant, specifically in Washington County, but helping out in other ways that I can. I'm running the live stream today, and then any sort of WebEx issues or questions that you all have, you can refer to me.
Thank you, Sam. Sarah Friedman.
Yeah. Hi, everyone. Sarah Friedman with the Council of State Governments Justice Center. You all are going to be hearing a lot from me during this meeting with that slide deck that you all got yesterday. I'll be presenting a good chunk of that.
Okay, thank you. Alice Emmons. Alice, I think I missed you last time, and I sincerely apologize.
That's fine.
I'm sorry about that. Please introduce yourself.
I'm Representative Alice Emmons from Springfield, and I am one of the legislative appointees to the working group. I'm also chair of the House Corrections and Institutions Committee.
Thank you, Alice. Allison Hart, please.
Hi, good morning. I'm Allison Hart. I'm with the Agency of Human Services in the Secretary's office.
Thank you very much, Allison. Angie Gunter.
Hi, everyone. I'm Angie Gunter. I'm with the Justice Center. I am a senior research associate, and I am continuing work that Ed started last year.
Thanks, Angie. Ashley Messier. Or Messiah. Sorry.
That's okay. It's Messier. I'm Ashley Messier. I'm the executive director of Justice and Freedom Initiative, and I'm a commissioner on the Vermont Commission on Women.
Very good. Thank you, Ashley. Dale Crook. Sorry, I need my glasses. There we go.
Yes, hi, Dale Crook. I'm the Director of Field Services for the Vermont Department of Corrections.
Thank you, Dale. David Demora.
Good morning. My name is David Demora, and I am a senior advisor with the Council of State Governments Justice Center, working here in Vermont with the rest of the team. I was involved in parts of phase 1 and will remain involved through phase 2 or implementation.
Thank you, David. David Scher.
Yes, David Scher with the Vermont Attorney General's Office, representing the Attorney General.
Thank you, David. Dick Sears.
I have to unmute. Dick Sears, State Senator, Bennington County, Chair of Senate Judiciary, and actually a member of the advisory board to the Council of State Governments.
Thank you, Senator. Falco Schilling.
Hi, I'm Falco Schilling. I'm the Advocacy Director for the ACLU of Vermont here on behalf of James Lyle.
Thanks, Falco. Brian Grierson, Judge Grierson. Brian, you with us? All right.
Nope, here I am, Chief.
There you go. There you go.
Yep. Brian Grierson, Chief Superior Judge. Good morning, everybody. Good to be with you.
Thank you, Brian. James Pepper.
Hey, sorry. Yeah, James Pepper, representing the Department of State's Attorneys and Sheriffs.
Thank you, James. Jill Evans. You're muted, Jill. There you go.
I double clicked. Sorry. My name is Jill Evans. I'm a director of one of the community justice centers in Vermont.
Thanks, Jill. Judy Henkin.
Good morning. This is Judy Henkin, Deputy Commissioner of the Department of Corrections.
Thanks, Judy. Karen Tronsgaard Scott.
Good morning, everybody. I'm Karen Tronsgaard Scott. I'm the Executive Director of the Vermont Network Against Domestic and Sexual Violence.
Good morning. Thank you, Karen. Kelly Doherty.
Good morning, everyone. My name is Kelly Doherty, and I'm a Deputy Commissioner at the Department of Health, and one of the areas I oversee is our Alcohol and Drug Abuse Programs Division.
Thanks, Kelly. Loretta Sacchi.
Hi, my name is Loretta Sacchi, and I'm a policy analyst with the Council of State Governments Justice Center. Thank you.
Thanks, Loretta. Madeline Dardo.
Good morning, folks. My name is Madeline Dardo, and I'm also a policy analyst with the CSD Justice Center.
Thank you. Martin Lalonde.
Yes, Martin Lalonde. I'm a representative from South Burlington, and I'm on the House Judiciary Committee.
Thank you. Mary Jane Ainsworth.
Good morning. I'm Mary Jane Ainsworth. I'm the Executive Director of the Parole Board.
Okay, thanks. Monica Weber. Monica, you're muted.
Hi, everyone. Sorry. I'm Monica Weber. Hello. I'm the Administrative Services Director for the Department of Corrections.
Thanks, Monica. Morning Fox.
Hi, this is Morning Fox, Deputy Commissioner for the Department of Mental Health.
Good morning. Thank you. Matt Valerio.
Morning, I'm Matt Valerio. I'm Defender General for the state of Vermont.
Thanks, Matt. Pat Gable.
Good morning, everyone. It's great to see so many of you here today for this. I'm the Vermont State Court Administrator.
Thanks, Pat. Kurt Taylor.
Yes, Representative Kurt Taylor from Colchester. I'm on House Corrections and Institutions.
Thank you. Maxine Grad.
Good morning, Representative Maxine Grad. I'm one of the House appointees and I chair the House Judiciary Committee.
Thanks. Susanna Davis.
Hi, buenos días. I'm Susana Davis, Racial Equity Director for the state.
Thanks, Susanna. Okay, well, that's our list, and thank you again. Thank you all for joining us. We've got 30 participants here this morning, and that's a terrific turnout. Appreciate everybody's involvement. I'm going to turn it over now to Sarah Friedman, who is going to present for CSG. Sarah?
Thanks so much, Chief. Hi, everyone. I am going to share my screen right now and get the presentation up. So bear with me 1 second. Let's see. All right, can everyone see that? Hoping. I can't see you all actually to know if folks are nodding along.
We can see it.
Thank
I
you.
can see it, Sarah.
Thanks so much. So I know I just introduced myself, but I'll do it again. Hi, Sarah Friedman, Deputy Program Director at the Council of State Governments Justice Center. In my role at CSG, I actually oversee the implementation of justice reinvestment legislation across all of our different states who have recently passed JR bills. Hold on, I'm having, there we go. And now the slides are moving, I hope. So I think that folks in this room really should, by this time, know who the Council of State Governments is. We've been running around Vermont for a long time for this project since summer of 2019, working on what we call phase 1 of justice reinvestment under the leadership of Ellen Whelan Wiest. So for the presentation today, we're going to do this in 4 parts. First, we're just going to do a quick refresher of what you all covered or what you all decided last month on your September 30th meeting of the working group. So in case some folks couldn't make it and are now here today, or just to kind of refresh everyone's memories, as that at that first phase 2 working group meeting, the working group did set the priorities for the next couple of months of work. Then, because the priority that was chosen, one of the priorities that was chosen to be covered today was tackling the statutory duty to discuss earned credits for people on probation, I'll be giving an analysis of Vermont's probation system based on all the data that is available to the CSG Justice Center, and then roll into a section that gives policy examples from other states who have worked to transform their probation systems, and turn it over to you all to have a discussion of that earned credit policy for folks on probation. After that, as the chief said, we will have a break and let everyone stretch your legs, do what you need to do, because 3 hours on video conference is a really long time. I'm sure all of you have been thinking this. And then I will pass the baton to my colleague, David Demora, who introduced himself and also should be a pretty familiar face since he's been working in Vermont for a while. And he'll give the 4th section of the presentation about behavioral health in Vermont. So as the chief said, I really welcome interruptions, although I can't really see you all. So if you have questions as we go, don't hesitate to don't hesitate to just interrupt. To interrupt, although and ask your questions, probably by unmuting yourself. If you don't feel comfortable doing that, feel free to put them on the chat, and I've asked my colleagues to interrupt me if questions come in on the chat that makes sense for me to answer in that moment. But I really prefer taking questions as we go. One thing I want to note before I dive into the presentation is that during the last meeting and in materials that I sent out that kind of outline the next 4 meetings of the working group and what the group will be covering, or I should say that this meeting and the next 2 after. I had been using the term earned good time on probation and got feedback that was pretty confusing since Act 148 has earned good time for folks in the prison system, and also that the statutory language in Section 21 really says earned credit. So if you all notice that I've shifted how I'm referring to this, and you have some earlier materials from me that say earned good time, and now I'm saying earned credits for probation, that was a really conscious effort to kind of make sure that two concepts are being adequately differentiated from each other. And I hope that will make things less confusing moving forward. So as a refresher, this working group was reconstituted in Section 21 of Act 148, which is the justice reinvestment legislation that was enacted in July of this year. And Section 21 reconvenes this group, adds a member of the parole board to the group. So Mary Jane is here. We welcome her into the fold, and then has a kind of pretty long list of specific tasks that it wants the working group to do, along with reporting requirements on January 15th, 2021 and January 15th, 2022. So in the last meeting, we discussed that list of statutory requirements in Section 21 and those 2 reporting dates of January 15, 2021 and January 15, 2022 to determine what was really realistic to cover before that first reporting date this January, which feels extremely soon. So we're kind of in a race to the working group's first reporting date. So here's a list of all the statutory duties that were listed in Act 21. But also, in addition to that, just to remember, although it's not explicitly in one of these bullet points, a key requirement of a working group now that Act 148 has been enacted and Vermont has transitioned into what we call Phase 2 of justice reinvestment, the implementation phase, is that in addition to these statutory duties, and kind of the studies that have been given you, the working group is here to make sure that you're overseeing implementation of the new policy changes in Act 148. So moving forward, the role of the CSG Justice Center with the working group is really to assist you all by providing data and policy analysis regarding all of these things you're studying, communicating what best practices are from other states, sharing relevant research, kind of what works in the criminal justice field, and facilitating a collaborative data-driven process. So for right now, we're helping you tackle this list of duties as we're also simultaneously working with your state agencies to help them get the policy changes up and running. And into 2021, we'll also be helping you understand what is going on with the implementation of Act 148 and have data and provide data and analyses focused on those policy changes as well. So last meeting, looking at that long group or that long list of items, the working group decided to tackle 4 items. The first 2 that are listed here, studying the earned credit for people on probation and identifying ways to increase risk assessment information sharing. Those are actually required in statute to be done and by that January 15th, 2021 reporting date, the first reporting date. Other things had more flexibility as to whether you do them by 2021 or 2022. But as discussed, 2, 3, and 4 really can go together hand in hand, looking at the risk assessment and behavioral health screening assessments, case planning and care coordination all together. So we decided that we could tackle those quickly, but kind of as a group. So also in the last working group, we set out under the chief's leadership, the meeting schedule leading up to January 5th, 2021, that first reporting date. So you see here the Phase 2 justice reinvestment timeline so far. So when the bill was enacted, when you all were approved by Bureau of Justice Assistance, the Justice Reinvestment Funder, to be a part of phase 2, and then the 4 working group meetings prior to that first reporting deadline. So we're obviously on October 27th right now, and you all have 2 more meetings before January, November 24th, and then January 11th. It's also just important to remember that there are some reports in Act 148 due on December 1st. Key policies are effective on January 1st of next year. And then, of course, as I keep mentioning over and over again, January 15th reporting deadline. So when we went to combine the meeting dates and the priorities set out, we determined kind of what would be covered in each meeting moving forward. So here we are today discussing earned credits and behavioral health screens and assessments. In November, will be more heavily focused on behavioral health information sharing, care coordination, and case management. There was also a request to kind of consider justice reinvestment funding for the upcoming budget cycle. And then January 11th will be probably a bit of a marathon of a meeting where we receive implementation updates of all of that work that's gone into those January 1st effective dates, discuss all of the different reports that were required to be submitted as part of Act 148 in this period, review any policy options related to the discussions that we all have been having over this period. And then, of course, this group will be required to continue meeting into 2021 and figuring out what that looks like. All right, so now I'm diving into Vermont's probation system. So as part of the Section 21 of Act 148, you all are required to study a policy for people on probation earning 1-day credit towards their suspended sentence served in the community without a violation. There's also a list of other considerations in statute that to take up related to this earned credit policy. What the CSG Justice Center staff have done moving forward in this section is based on data that we received during phase 1 of your process, so historic data submitted to us by DOC and the court system, how can we help guide you in answering some of these questions? What do we know about your probation system? And so that's this section that I will be getting in moving forward in order to set up a conversation where you all can discuss these statutory considerations. So under probation, if someone is found guilty of an offense, they are released by the court to community supervision. In Vermont, sentences to probation actually have 3 different components. People are given a probation term, such as 12 months on probation supervision, but they also are given an underlying term of incarceration that's suspended with a minimum and maximum sentence for that. So, for example, someone might be given for misdemeanor probation 12 months of misdemeanor probation with an underlying minimum of 3 months of incarceration and maximum of 6 months of incarceration. For felony probation, that might look more like they're given 4 or 5 years of felony probation, and then, say, I'm making this up, but something like a 12 to 5 year underlying sentence of incarceration. You'll see data later in the deck about exactly what those underlying sentences of incarceration look like. So it's really important, though, to understand these 3 components of a probation sentence, because a lot of the statutory requirements ask you to consider how, if someone is going to earn credits, how are they going to earn, how are those credits going to impact all 3 of these different components of a probation sentence. So probation is administered by the Department of Corrections. But the terms of condition, releases, violations, discharges are all determined by the courts. So in many ways, it's a partnership between DOC and the courts. So the judge sets the conditions of probation, adjudicates probation violations, and decides if a person is ready to be discharged. If that discharge comes up before their maximums, before their probation term ends. DOC supervises all statuses of community supervision, and it's actually DOC that files with the courts probation violations and requests for discharge. So here we have what many people in the room will think is a too streamlined flow chart of how someone might work their way through the system when they're sentenced on probation. So apologies for those of you who really know the ins and outs of the system. This is definitely in order to fit it on a slide and make it easy to read, we've definitely streamlined this there are definitely some scenarios that this does not quite represent. But for the case of today, I think it's a good conversation starter for understanding what happens when people are put on probation. So you see in the green, when someone initially commits a crime and goes in front of the court, that's how the green shows you how someone kind of gets on probation. And then what can happen to them. So there are mechanisms to successfully end their probation. Those are in orange on the right side of the slide. And then there are kind of what happens if someone is not successful on probation. So they commit a violation, they go up in front of a judge, they can either have their probation modified, that's stayed in green there, and go back on probation, or they can be revoked. And in that case, they go into a different type of DOC custody and start serving their underlying minimum maximum sentence of incarceration. And then once they're in the DOC kind of prison population, they can go through the DOC system the way everyone else does. So there's a potential that they get released on furlough supervision, often at their minimum sentence. They can also, go through the parole process and become part of the parole population. And of course, if someone is continually cycling and not doing well on incarceration, they may cycle through, be revoked from parole or from furlough and get back into incarceration. So, but we're here to think about these earned credits on probation, which are, discharging mechanisms for people to earn early discharge from either their probation sentence or to limit their underlying incarceration sentence. So it's really important to understand these mechanisms that currently are on the books in Vermont for how someone might actually earn an earlier discharge from probation. So right now, you all do have a midpoint review that's mandated in statute. So at the midpoint of someone's probation term, DOC conducts a case review and then can submit a recommendation to the court for earlier discharge or a term reduction if at that midpoint review they find that that person is being successful on probation. There's also a mechanism for DOC to request discharge for someone, an early discharge for someone on probation if they've completed all of their conditions. So if they've been complying with all of the terms of probation and DOC thinks the person has been really successful, they can also petition the court to have that person released early from their probation term. So the next bunch of slides just go into who is in your probation population. So when we're thinking through all the different types of people in Vermont's criminal justice system, who are we talking about specifically right now? So here we have all of the different types of DOC populations under their jurisdiction. And you can see here that really there's a lot more people on probation than sentenced in prison, on parole, or on furlough supervision. And over the last few years, and I should say over actually a pretty significant amount of time, the probation population has been dropping. So this is since between 2016 and 2019, over a 4-year period where the data was available, your probation population has dropped 16%. If you were to look further back, you'll see that this has been a steady drop for some time now. when you look at the kind of various demographic makeup of folks on probation, you'll see that there's a larger proportion of women on probation than there are compared to other types of DOC populations. 25% of the people who are on probation are women. You'll also see that there's actually a smaller proportion of Black people on probation than there are in other types of DOC populations. So 3%, if you look at the racial makeup of probation, 3% of people on probation are Black, compared to, for example, 9% of people in the sentenced population. So here you'll see that the majority of people on probation are actually there for misdemeanor offenses at 58% of the population. Again, this is a much larger proportion of people in this type of community corrections for probation compared to other types of offenses. Now, if you look at those probation if you look at people who are on probation by misdemeanor and by felony, you'll see that they're there for kind of different types of offenses. So the majority of or the largest group of people who are on misdemeanor probation are there for motor vehicle offenses, whereas the largest proportion of people who are on felony probation are actually there for violent offenses. And you can see here that, only 11% of people are on felony probation for motor vehicle offenses. However, there is, a good proportion of people on misdemeanor probation for violent offenses at 34%. So if we dig a little further, just thinking through kind of what type of offenses further people are on probation across both types of probation, misdemeanor and felony, you have 34% of people on probation for listed offenses, which again is kind of the smallest number across the various different DOC populations. So now we'll go through both misdemeanor and felony probations, looking at what those kind of sentence mechanisms look like. So there's already statute on the books in Vermont that says that misdemeanor probation sentences are not to exceed 2 years unless the court deems a longer period appropriate. And with this, you'll see that misdemeanor probation sentences are really do kind of follow that guidance. They're most often 1 year in duration, and almost all probation sentences are less than 2 years, so 24 months on this graph. This statutory guidance seems to have made misdemeanor probation sentences pretty consistent across different demographic types, geographies, and offense types. So if you look at misdemeanor probation sentences by sex and race, it seems like on average, everyone, and you average those out, everyone on average gets 12 months of probation sentence. By offense type, person and drug offenses do get slightly longer sentences. And if you look at geography, it's relatively consistent, although there are some geographic distances as we work our way across those counties. Now, the underlying suspended sentence that is paired with those misdemeanor probation sentences does look a little different. So for misdemeanors, these underlying suspended incarceration sentences are actually generally significantly shorter than misdemeanor probation terms. So overall, across everyone who's sentenced to misdemeanor probation, the median minimum suspended sentence is 3 months, and the median maximum suspended sentence is 9 months. So across everyone, people on misdemeanor probation generally typically get 3 to 9 months of an underlying suspended sentence. And if you look across on the left side of this graph, you see what their sentence probation length is. And then the bars demonstrate what that underlying sentence is typically, so the median underlying sentence. And you see that even as the sentence probation length goes up, it typically, the maximum sentence stays at 1 year. So even as the sentence goes up, the underlying sentence does not change that much across the different probation sentences. Now, if we look at those minimum and maximum underlying sentences by offense type, there is some variation. Not totally surprising that person offenses generally have the highest minimum sentence. And so for 6 to 12 year sentences, minimum, maximum typically. And other offenses are kind of lower in what they receive the minimum and maximum sentences. So now on to felony. So we're going to just kind of repeat all these charts for felony probation. So this is similar to misdemeanor. There is statutory guidance on how long felony probation sentences should be. And that is generally that they are not to exceed 4 years unless the court deems appropriate. Now, we do see a kind of more variation in felony misdemeanor sentences than we do in misdemeanor sentences, or felony probation sentences than we do in misdemeanor sentences. So you'll see here that this chart does go up to 5 years, 60 months. And there is a chunk of people who are, generally sentenced above that 4-year guidance, but it's still the majority of people are staying within the 4-year guidance, with the largest number of people really getting 3 months of felony probation. Again, when you look at felony probation sentences across demographics, offense types, and counties, there's a lot of consistency. The average probation term across almost everything is 36 months, so 3 years. Men and women, 3 years. Different type by race, the races get 3 years. By offense, 3 years. And then again, a little more variation by geography on that average probation length. So unlike misdemeanor probation, the underlying sentences for felony probation sentences look a little different. So most often, the maximum incarceration sentence is the same length or is around the same length as the probation sentence once the sentences are 3 years or more. So, someone gets a 3-year probation term, their maximum incarceration sentence is also 3 years. 4-year probation term, their maximum suspended incarceration sentence, also 4 years. However, that's not the case for people with shorter felony probation sentences. Those maximums are actually longer than their probation terms. So if you're sentenced to for example, on this chart, if you're sentenced to 1 year probation term and you mess up and get revoked, you actually have a maximum underlying incarceration sentence of 2 years. So you could, in theory, potentially be incarcerated or kind of be in correctional control for an additional year past your probation term. So overall, if we look at all felony sentences, the median underlying sentence for all felony probation lengths is 1 to 3 years for a typical person. Again, if you look at what those median and maximum sentences look like by offense type, the person offense types have longer underlying sentences. They go up to the median and maximum. Sorry, saying median maximum a lot is a real tongue twister, but that median maximum is up at 60 months, so that's 5 years for people with person offenses. But for drug, motor vehicle, and other, you're at that 3-year mark, which is that average, which is also most people's average probation length. So I think it's important to understand how people's success or failure on probation might be driving other parts of Vermont's system. So this is a chart that you all saw in phase one, as were some of the previous slides. Some of those slides I've been presenting are new, and some should have looked really familiar to folks who were involved in the phase one process. And this is this is the people being admitted to DOC to the sentenced incarceration population at DOC. So probation violators make up 20% of DOC prison admissions. That's equal to the number of people coming into prison for new court commitments, so having committed new offenses. But as I think was a large topic of conversation during phase one of this process, not nearly as many people who are coming in for furlough violations. So for people who are being revoked to prison from probation, from what we can tell, again, this is from phase one data, it's a pretty even split as to whether people are coming back to prison for technical violations or new crime violations. And I have a feeling most people know, but just in case folks are wondering what technical violations are, those are people those are violations when people mess up on their terms of supervision. So, but not public safety concerns. So not people who have committed new offenses or, have not people who have committed new offenses, but people who, have violated those conditions that judges put them on around their supervision. So sometimes that's, consistently being late to meetings with POs, perhaps, along with, failing drug tests, not showing up for work, there's a whole long list of what technical violations can be, but those are, not new crimes. So when violation,
Can I ask a question about slide 30?
Yes.
That seems to be a key area, at least for me, in looking at where the problems lie. And we focus so much on furlough, but you're saying 20% of the 10% of the 541 probation violations. What's the actual raw number of the probation violations that are from new crimes? Do you know the nature of the crimes by any chance?
So sorry, is this the right slide? The technical versus new crime violations. This is the right slide. Yeah.
Yes. Yeah.
So I would actually perhaps ask Monica Weaver at DOC to speak up about this, because I know that she worked really closely with Ed Weckerly, our phase one researcher, on figuring out this slide. Just note that this was a sample that they pulled. They weren't able to look at, all because of kind of my understanding, and Monica, I hope you don't have to correct me, but my understanding of just kind of how the DOC data polls looked, they had to pull a sample. They weren't able to look at absolutely everyone in order to kind of get a sense of how people are being revoked.
I would suggest that it would be helpful for us at some point to know the nature of the offenses that people are being, the nature of the offenses or new crimes that people are being violated on furlough, probation, or parole, which is about 78% of those on. So it just would be helpful to understand whether they're minor infractions or they're very serious. Is it driving with license suspended as a new crime, or is it a robbery or something of that nature?
I can't, I'm not sure what's available to us, but that's definitely something that we can explore and see if we're able to do that.
That would be extremely helpful in trying to come up with ways to reduce the number of people who are, because when they commit a new crime, it's, my first reaction is, well, that they should be returned. But I don't know the nature of the crime to be able to make that response.
Sarah, I do think that Dale also might have some information about this, since his group supervises those probation violators, and has some probably a little bit, not hard quantitative data, but could probably speak also to some of the things that you were talking about around technical violations. I do think we want to maybe add a little bit more context to the type of technical violation that we're looking at when we think about a revocation. And I know, Dale, you probably have some thoughts about that. But for the new crime piece, we didn't get into that in phase one. I think it was just more of a timing issue. We didn't really get into the details on that. I understand why that would be important. I think that's something that we'll probably be able to look at moving forward.
Thank you.
Great. Thanks so much, Monica. So, so as we look at what happens once a violation is in front of a judge, in 34% of those cases, the judge does revoke their probation, or revoke it completely, or revoke it with a split sentence imposed. So 34% of the time, those people do enter incarceration. Interesting to note that also, in 35% of the time, the judge does affirm, yes, a violation was committed, but they reinstate probation. And 19% of the time, the judge does not affirm that violation. And so that violation is dismissed, and then the person would also go back on probation. So really, especially if we're thinking about, when or how, or, what mechanism should be to shorten probation revocation, to shorten probation sentences, and whether that's necessary, it's really important to think, to understand, when does the average person violate their probation sentence? So how long are people on when people do violate probation, how long are they on probation successfully? Before they mess up and come back in front of the judge. So for misdemeanor probation, we have this chart here based on how long they've been sentenced, how long their sentence probation length is. And you can see that most revocations occur well within the first half of someone's probation sentence. So the average revocation, on average across all different sentence lengths, a person is revoked in their 7th month of misdemeanor probation supervision. And as those probation sentences go up, you do see a general trend where people are successful for longer on their probation before they're violated, if they are eventually revoked to probation. But and if you look at this by offense type, you see that across different offenses for misdemeanor probation, on average, people are revoked within their first 8 months of being on probation. So same data, just cutting it in a different way, looking at what offense people were convicted for. Really interestingly, so on average, it's 8 months, but for median, so for the typical person, this is actually even lower. The typical person would be revoked in their 5th month of their supervision term. So very similar to misdemeanor probation, on felony probation, people are also revoked within the first half of their probation sentence, often well within the first half of their probation sentence when they have longer sentences. So on average, a person on felony probation who is revoked in the 11th month of their supervision. So within the first year that they're on felony supervision probation, people are more likely to be revoked. And again, similar trend for the most part, that as people's probation sentence lengths get longer, they are successful longer on probation before that, before they are revoked on average.
Sarah, can I add a couple of points?
Yep.
Hi, folks. This is David Demora. Just a couple of additional points. One is that finding of people being more likely to be revoked very early on is typical. It is not unique to Vermont at all. And it's one of the reasons why when we talk about front-loading supervision and about that it's extremely important to provide the greater intensity of services as early as possible, because that is when people are most likely to fail. I think it's also important, particularly in your misdemeanor population, to look at the number of people that fail related to drug and motor vehicle offenses or problems. Again, we'll come back to that later when we talk about behavioral health, but that's, I think, very important when we think about what do we need to do to try to lower people's failure rates. And then finally, what you'll see, excuse me, in the time frames is people tend to survive longer, but there does tend to be a cutoff. And although we haven't carried this out all the way because it wasn't what we were looking for, when we look at data across the country, at a certain point when probation just goes on and on and on, you begin to see the violation rates increase. Essentially what happens is people give up hope and they begin to not follow what it is they're supposed to do, and you see an increase in that failure rate. Your increase in Vermont isn't that significant at all compared to other states, but you can see it as people get into that 4, 5, 6, 7 year period as well. Thanks, Sarah.
Thanks, David. That's really helpful. And I think that you do see here, across both misdemeanor and felony, but it's true, as you say, definitely for misdemeanors, people mess up early. People, on average, folks are not hanging out on probation for long periods of time before they mess up. Within their first year, within the first half of their probation sentence length, that violation occurs that puts them serving their underlying incarceration sentence.
Sarah, this is Alice Emmons, and I have a question about the average time for revocations for the misdemeanors, and looking at it's slide 34.
Mm-hmm.
I'm just really curious. The bulk of it is motor vehicle, which is 8.1. I'm wondering how much of that is really tied to folks not being able to get their driver's license back due to maybe other issues, that they can't afford the fines, they can't afford to reinstate their license, but they need to get to work. So they're driving to work. That's one question I would have about motor vehicle violations. And then the other one, in terms of property or person, how much of that may be related to domestic violence as well? If some of that are not the drivers, I don't know. I'm just doing a deeper dig that you may not have been able to do.
Yeah, those are really interesting questions. We just have the numbers from the courts data, so no kind of qualitative color to the numbers that we're presenting here. But I would be curious to hear from other folks on the working group on their experience, perhaps the Defender General's office or the state's attorneys, that if they're seeing these revocations, what they look like for the different offense types. Well, I would encourage the conversation to continue. We're going to have a moment for everyone to talk about this moving forward. So encourage folks to speak up, and I share your curiosity, Representative Emmons. So I believe we covered this. Let's see, the felony probation length slide. That people on average across all different sentence lengths are revoked within their 11th month of supervision. So before they hit the year mark on their supervision sentence. And if you look at this across offense type, you can see that people charged with probation, or charged with property offenses, actually pull up the average there, that those people are successful on probation on average past the year mark. And it's also important to note that we're talking about averages here, but if you look at the median, which might be more of the typical case, the median time to revocation is lower than the average. That's people being revoked in their 8th month of their supervision term. So I think just to build on what David said, I think that one thing you can consider when looking at this data across misdemeanor and felony probation is that, you know, at what point do we understand people are public safety risks when they're on probation? And when do folks in the state feel comfortable saying, you know, like this person has been successful for a typical amount of time or for a certain amount of time. They haven't messed up as someone might as someone who messes up when they typically do. So we're comfortable, you know, releasing them from supervision because the data shows us that, you know, they're unlikely to mess up if they've made it successfully this far on their probation sentence. So once people are revoked to prison, though, they have an average length of stay in incarceration from probation of 101 days. So this slide should look familiar. This was something that, again, was presented during phase 1. Not that you all need to remember all of the many, many hundreds of charts we presented to you, but we presented to you in 2019. But again, just looking at, I think again that when this was initially presented, folks were focusing on furlough, on the furlough piece. But it's important for this conversation as we see here that of the 3 types of community supervision, people who violate probation do stay longer in prison. So on average, 101 days. So for median, 48 days on that revocation. Oh no, did I lose you all? Shoot.
We lost the slide, Sarah.
You lost the slides. Yeah, I can tell something happened. Let me share again. All right, hopefully we are back in. That was odd. Yeah, presentation mode works. Okay. So also in phase 1, we looked at what the probation outcomes are for people based on their risk to recidivate. So your probation system is really interesting. DOC does a screener for people who initially come in probation to determine whether or not they need a full-blown risk assessment, the ORS assessment that's used throughout DOC's system. And the majority of people who come into DOC system are actually screened by the screener as so low risk, they don't need to go through the rest of the risk assessment process. So that's the bar all the way on the right on this graph, which with people with unknown risk level are actually people who have been screened as very low risk. And so it's not surprising then that people who are screened as very low risk to recidivate actually tend to be really successful on probation. 81% of these people who are low risk enough that they didn't need a larger risk assessment do end up being successful on probation. As you look at the rest of the chart, you see by risk level. So for the rest of the folks who were screened by that screener and determined that they did need the full ORAS assessment, that as their assessed risk goes up, they are less likely to be successful on probation, which is actually exactly what we want to see for a risk assessment. It's a rough way to validate that, the risk assessment is telling people that they're more risky, and then you see that are more likely to fail. For example, if you look at those folks in that the 29 folks in the very high risk category. There's another argument here that you really need to think about how you allocate resources and where your probation officers are then spending their time. So you really want to focus. You really want officers focusing on. Whoa, that just moved without me doing anything. So I think I have a little bit of a ghost in my screen right now. But just to continue the conversation, that you really want, you do really want people focusing on, you want your probation officers focusing on supporting and tracking those really high risk people to reoffend, and helping and not focusing on kind of catching low risk people who are doing successful doing there we go. And not focusing a lot of energy on these low risk people who are going to be, the nature of kind of how risk to recidivism works. These people are going to be successful, generally going to be successful on probation without a lot of intervention.
So, Sarah, may I add a finer point as well?
Yes, please.
One of the things that we have done in the field is we have shortened the descriptions of what are risk and needs assessments to risk assessments. We all do it. Everybody I know does that. The assessments are risk and needs assessments. For every risk that somebody has, there is an accompanying need that needs to be ameliorated in order to lower that degree of risk. And so when we talk about more attention being paid by officers to those who are higher risk, for example, we don't simply mean watch them closer. What we mean is to make sure that there's a clear identification of what those needs are that are connected to the risk factors, and then getting those folks to the appropriate interventions. Sometimes officers do that themselves, meaning officers are trained to do a number of things. Sometimes they need to get them involved with other programs. I bring it up here because when I'm talking later, I'm going to be talking about some of the problems with those connections that need to be further improved, despite the hard work that everyone is doing. And so I just want to make that finer point that although we often talk about risk assessment tools, they are at this point clearly risk and needs assessment. Just knowing someone's risk is not useful. Knowing the needs that are connected to that risk are what allow us to make the necessary interventions for those folks.
Thanks so much.
Excuse me. Sorry, Sarah. This is Karen from the Vermont Network. I want to raised by Representative Emmons regarding the rates of domestic violence among folks that are revoked. I want to point out that the ORAS does not test risk for domestic violence, and so that's a real gap in our understanding of how people are likely to run into trouble once they're released on probation. Thank you.
Thanks so much, Karen. So that actually, now that we look at it, and the ghost that's moving my PowerPoint slides, that is the last chart, I believe, that I am showing you today. So you made it all through the quantitative section of this, of the largely quantitative section of this presentation, that shows you the data that CSG is able to present to you on the probation system. I would say that when we were thinking through, how do you analyze potential impacts of a probation credit accrual policy or improving earned discharge processes or a variety of different policies that you all could do to get towards a goal of helping successful people earn their discharge, the data that we had available to us didn't get us all the way there. So the CSG team definitely has some unanswered questions that I'm sure some of the experts in this room, the Vermont experts in this room, might have some ideas of how to get towards. But we definitely think that there could be more exploring to do around this. We have in the orange, we have these two mechanisms already in place to help people earn their discharge from probation, but we actually don't have any sense of how and when they're being used currently, how often they're being used, and when they're being used, how long of the sentence that people kind of get cut off. So, at what point within their sentences do people earn discharge when these mechanisms are being used? We don't have a sense right now of, the challenges that people face when attempting to use the current early discharge mechanisms. We also don't know all of the relationships between those. We kind of know what the minimums and maximums are now, which was new data that you all saw for the first time today for the underlying incarceration sentences, but we don't really know how they relate to what happens when someone is revoked. So, how do they correlate with the amount of time someone actually spends in prison? And if people kind of are revoked from probation and then placed on furlough and parole, we're not able to track people to see if are they more successful on furlough or parole? Are they still cycling through in the same way? We're kind of not able to track how individuals move through the system and then move into different types of DOC supervision and what their success looks there. Right. So now we're going into just other policy examples from other states, and I'll be kicking off the discussion for the working group on all of those statutory requirements in Act 21 around the earned credit policy. So the first thing, and I mentioned this in the beginning, but I guess I'm putting a finer point on it here, which is that actually Vermont has probation sentencing structure is unique in the country. So when we're looking at the state examples to come, just to keep in mind that you all do it differently than all of the other states I'm presenting to you. So in every other state, there are generally two types of probation sentences that other states use. First, some states sentence a person directly to probation, and then so they're just given, say, hey, you're going to probation for 12 months, or you're going to probation for 24 months. And during that 24 months, at any point, if that person messes up on their probation and is revoked, they then would go back to incarceration for the full length of the initial probation sentence. So there isn't an explicit there's an explicit underlying incarceration sentence on the books. Rather, whatever the probation term is kind of their incarceration sentence. So, worst case scenario, a person is on probation for 24 months, has a 24-month sentence. They mess up in the 23rd month, they would go back to prison in this system for an entire 24 months. That's actually typical across the country. Then the other way others structure their probation sentences is that rather than giving a sentence of probation, they just give a suspended sentence. So a judge sets a maximum and minimum suspended sentence of imprisonment and just says, hey, it's suspended. They don't set that third part that Vermont does of an additional probation term. Just they're on probation for the length of their suspended sentence. So in this scenario, if a judge says, hey, I'm giving you a 1 to 3 year term of imprisonment, but I'm suspending it, what's implied there is then that person's probation term is 3 years. So Vermont is unique in the country of having 3 different parts of the probation sentence structure that can shift and aren't as related to each other as in other states. So when moving forward, what you're going to see is different ways that people can earn discharge off their probation sentence, or different ways, different policies that states have put in place to reduce the length of time someone goes back into incarceration when they violate their probation. That's the examples moving forward. We talked to a variety of folks preparing for this presentation about prior conversations that folks had in Vermont in the last legislative session and earlier about ways to the earned credit policy or ways to modify Vermont's probation systems. And we lift up these three types of policies across the country because they seem to get at different aspects of people's goals of a variety of people's goals for the earned credit policy. So 38 states have some form of earned compliance or earned discharge for people on community supervision. However, they are often set up very differently. So when I'm talking about earned discharge or earned compliance credit, this is to cut short people's probation terms. This does not impact that underlying sentence of incarceration, just to be clear. It's just that if people are successful on probation, they can earn their way off of it. So there's two mechanisms to do this generally. One is the compliance credit. So that's the set formula in statute that enables people to kind of automatically earn time off their probation sentence as they comply with supervision conditions. There's also a mechanism that many states have adopted that's earned discharge. So rather than having a credit accrual system, in statute, it says, well, once a person has been on probation for a certain amount of time and they've been successful and complied with all of their different conditions, then they can apply to be discharged from supervision. So it's based less on earning a certain amount of earning credits and more on just getting to a certain point in the probation term and seeing how successful they're doing. Research has shown that these types of earned discharge policies do incentivize good behavior to help people succeed on community supervision. So I know that you all talked a lot about on phase one about, set incentives and sanctions, positive and negative reinforcements for people on supervision. There's a lot of research out there on how to best support people to be on successful supervision, and earned discharge policies are part of that. It's a very large incentive to folks to comply with their supervision conditions and to really work to be successful on supervision if they know that they're working towards an earlier discharge by being successful on supervision. There's also has been research that has shown that an earned compliance policy credit has reduced supervision populations, so helping states with large supervision populations get people who are successful off more quickly so that they can focus their resources on people with the highest risks and needs, and that has been done without jeopardizing public safety. So Missouri is a really large example of, or is an example of a really large supervision system that created an earned compliance policy for both their probation and parole systems that that was really successful. So in 2012, through Justice Reinvestment, they modified statute to allow people to earn 30 days of credit to their probation or parole terms for every full calendar month that they complied with the conditions of their sentence. And those credits do automatically accrue to people who are on active supervision and complying with their conditions. But there were some carve-outs. They weren't available to everyone who was on community supervision in Missouri. It was really only available to people who are on lower level felonies. And they started accruing after the people had been on community supervision for 2 years, which means that people in Missouri are on community supervision for very long lengths of time. Not necessarily a problem that's facing Vermont right now for the majority of people. But Missouri saw a really large impact from this policy. So within the first 3 years, 36,000 people had shortened their probation or parole sentences by an average of 14 months. That caused Missouri's supervised population to fall 18% over the same period, which really greatly reduced caseloads for supervision officers and helped them focus on their high risk and high needs folks. They also did study the impact of this, and they found that people who earned credits were not later convicted of more new crimes of additional crimes more than people who who were in the system before the policy took place. So there wasn't a public safety impact of this policy in Missouri. On the other hand, so that's an example of an earned compliance credit. Montana is an example of an earned discharge. So in Montana in 2017, they set up what they call conditional discharge from supervision. And this actually, I shouldn't say they set it up, they actually beefed it up. They had a mechanism for earned discharge from supervision that really wasn't being utilized. And they chose within their justice reinvestment policy package to essentially mandate it be used more often and strengthen how it was being used and make it just make the policy much more clear than it had been before. So in Montana, the statute states that supervision officers must recommend discharge once a person on probation has served a set length of their sentence based on their risks to recidivate. Regardless of their underlying offense. So unlike Missouri, they didn't say, hey, some felonies, it's a step too far. This is for every single person on probation and parole in Montana. So for probation, it's once folks have been on probation once low risk folks have been on probation for 9 months, the DOC petitions to have them released. And that works their way up to high risk folks being on probation for 24 months. And I know, of course, this is pretty confusing in there. Median and moderate risk sounds the same, but I hope you understand from how this escalates that a moderate risk person in Montana, that would be someone who's like a medium high risk person. It's important to note that once the judge receives the petition from an officer in Montana or they are required to kind of determine that the conditional discharge from supervision is in the best interest of the person on probation, will not be an unreasonable risk of danger to any victims of the offense that the person is serving for, and to make sure that that person has repaid their financial obligations in full. It's important to note in Montana that the implementation is still ongoing on this, and I'll talk a little more about this, but their statute was written in a way that wanted their PPOs, their probation and parole officers, to file the petitions. That was found that wasn't palatable to the courts, and so now actually folks on probation file their own petitions with the help of the public defender's office in Montana. So some of the structure from the Montana, from how the Montana statute written ended up being modified in implementation. The other thing we wanted to present is we know that some folks in the state are interested not in just reducing that probation term, but in reducing the underlying sentence that someone may serve incarceration once they're revoked from probation after being successful for a certain amount of time. So the typical way that states have done this is something that's called a revocation cap. So this is a policy that when someone is revoked for almost always for a technical violation, the amount of time that they are allowed to be incarcerated for based on that technical violation is limited. Often to some amount less than a year. You'll see in the examples I'm about to share, sometimes much less than a year. So they don't go back to, it's a cap so that they don't go back to incarceration for the entire length of their sentence, but instead they go back to incarceration for a set period of time. Really important to note that revocation caps are not usually adopted kind of in and of themselves. They're usually part of a package of reforms aimed at improving community supervision. So other probation improvements would be along with tailoring supervision strategies to align what research shows reduces risk of reoffending, providing positive incentives, using other administrative responses in lieu of revocation. So, there's been a lot of conversation in Vermont about general like what does the research say to how to improve and improve community supervision, and revocation caps are usually enacted as part of a package that does that. So North Carolina very successfully adopted revocation caps along with a really large host of community supervision changes. So in North Carolina, the court can only revoke probation for new crimes, absconding, but if someone is being revoked for a technical violation, they are only revoked for 90 days. There's a 90-day cap. The only exception to that is if someone, so if someone has served 2 90-day periods and continues to mess up on their probation, so the third time they go in front of the judge after serving their 2 90-day revocation caps, then they can be revoked for the full length of their sentence. North Carolina found a lot of success across their community supervision reforms. So this, we can't separate how revocation caps worked in North Carolina versus all the other things they were doing at the same time. But as a result of the entire policy package, their revocation rate fell 18.6%, which was a 57% decrease in the individuals who'd failed on supervision. So their policy really helped people be successful on supervision. And it's really interesting to note that revocation rates for low-risk folks had the largest decrease, falling from 31% to 10%. So they were really able to get those people who were successful on supervision off their rolls and reduce the amount of low-risk people necessarily coming back into their system. Michigan enacted an even shorter revocation cap recently. So they limited the number of people who or limited the penalty for people on probation who commit technical violations to a maximum of 30 days. So no one who commits a technical violation in Michigan can go back for longer than 30 days, at least, again, similar to North Carolina, for the first 2 times they messed up. So once the person commits 3 or more technical violation revocations, then the court can increase the length of time that they recommend for incarceration. There is interesting to note that that there is a carve out here, and the courts are allowed to revoke people for a longer period of time if that person is waiting for a treatment bed. So they can be revoked to up to 90 days as they wait for a bed to be available if that's a person who needs treatment, who needs substance use treatment as an intervention. They also set up that you don't get credit for time served for those revocation caps. So if you keep coming back in and you end up being revoked for your whole sentence, you don't get to take those 2 30-day periods that you served on shorter revocations off the length of your entire sentence. So, we kind of searched high and low for the examples that were the closest to what we saw Vermont considering, and we couldn't really find anything that got to exactly what you all are thinking of doing, particularly around giving credits for that underlying incarceration sentence. The closest we got was Montana, who does allow, through this legislation that set up that conditional discharge policy that I just talked about, does allow a judge at their own discretion to credit time served on probation successfully to the time incarcerated for a revocation. So that's that's often called a street time credit. So getting credit for that time successfully in the community to the underlying incarceration. That is only at the judge's discretion, not kind of a requirement. We also know that there are some systems that have something similar for people on parole supervision at the discretion of the parole board. A parole board can consider cutting someone's incarceration short by crediting time served in the community. But Montana, as far as we know, is the only state that does this for people on probation specifically. And, as I've mentioned, that Vermont has, a really unique probation system. Montana isn't exactly the way Montana does it doesn't feel like a straight line to what Vermont is doing, but that's kind of the closest we've got to the underlying incarceration sentence. There's also been a number of implementation challenges in Montana since the 2017 legislation was enacted around the package of supervision reforms they do, and we're actually actively looking into into analyzing the outcomes of what's gone on in Montana as a result of that package of reforms, and but we don't know yet. And there is some anecdotes in Montana that as a result of the package of probation policy reforms, that it did change, that judges and prosecutors did change their behavior as a result of this attempt to shorten probation sentences. But I want to be really clear that there's conversation around that. It's unclear how well the implementation went. The jury's still out. We're helping them look into their data right now to learn more. So we don't have any concrete quantitative outcomes to present to Vermont around Montana. As kind of I mentioned at the end of the last sentence of the end of the last section, we don't really feel like we have adequate data on how this on how credit policy would impact Vermont's system in order for the CSG Center to come out and give support to a specific policy option. But we hope that by presenting this data and helping facilitate this conversation, we're helpful in exploring this policy proposal for folks in Vermont. And just continuing to beat the drum, and I know you all are going to hear from David on this as well, but whatever you all decide to do on making probation changes, just remember that it really needs to go hand in hand with efforts to help to support your probation officers or your community supervision officers in supervising people, as research says, best help people be successful on supervision. Accurately understanding people's underlying needs and violation behavior in order to connect those people to effective programs to address those needs. That we need to, everything needs to really be paired with a holistic approach to improving your community supervision system.
So Sarah, this is Alice Emmons. What's going through my mind in terms of Vermont's corrections structure versus other states? We have a system that's a little different in terms we have furlough, and not many states have that status. And I'm not sure if Montana or Missouri or North Carolina have that status. But what's striking me here about what they've done with probation and how it's a sentence and then they don't have an underlying sentence, either deferred or suspended. I'm wondering if they can do this up front because they don't have a release valve once a person's incarcerated like we do with furlough. And I wonder if that plays, this is just going through my mind, is that playing into what these states are doing up front in probation? Because once they're incarcerated, the only out per se is parole, where we have furlough, which is another check sort of on probation. Does that make any sense?
Well, certainly these states don't have a furlough system the way Vermont does. So that is another thing that's unique to Vermont. Other states may have something that they call furlough release, but it looks extremely different than what Vermont does. That's, letting someone off for a day to go to a funeral or, a doctor's appointment or something like that. So I think that is really true, Representative Emmons, that they don't have a backstop of a furlough system, all of these states, when they're looking into this, that these folks, that once they're incarcerated, it depends, because some people do get split sentences and might go back out on probation, but generally they would then be going through the parole, part of DOC population and then going through the parole system without the release valve of furlough. That's correct. So a lot of unique things going on in Vermont for sure. So now I'm hoping just to tee up this conversation for the working group and start hearing more and more from folks in the room. You know, our understanding is that there was language in S-338, which became Act 148, around a probation credit accrual, and that this language, I think, shifted throughout bill drafts. We did obtain the Senate version of S-338, which still had, you know, I think, but our understand, I hope, and you all can please correct me, but probably the last version of the probation accrual language still in it. So this was the version passed by the Senate in February 11th of this year. And in that particular version of this policy, the bill proposed a process for probation to receive 1 day credit towards their minimum sentence for each day successfully served on probation. It also gave guidelines for when a person would stop accruing credits and then how they could begin accruing credits again. And then there was also a requirement that people on probation be discharged when they accrue enough credit equal to their imposed maximum term of imprisonment. And that's pretty interesting because now we've seen that that could look very different for misdemeanor versus felony probation. We've seen that on misdemeanor probations, generally those maximum sentences are much shorter than the probation length, the probation term length. For felony probation sentences, for felony probation sentences of 3 years or more, the maximum would equal the probation length. So as I just recently mentioned, we talked to a variety of folks about this, as many as we were able to in the short period of time we were preparing for this presentation. And it became pretty clear that folks had different ideas of the goal of a policy like this. And so, we wanted to, I think that there are 4 different goals that these types of policies can get to. You might be trying to enact in policy that's to decrease the length of incarceration for people who are revoked to prison on probation, or you might be enacting the policy to decrease the probation term for people who are successful on probation. That I think is something that people might be on slightly different pages on, and what's most important here, although I'm sure a number of folks also are saying we're trying to do both. But understanding which of those goals, or if you're trying to get at both of those goals when you're crafting a policy around this. It's also important to note that, policy goals for this generally are to provide people on probation increased incentives for positive behavior change, and that these policies also can increase probation resources available to help officers focus on folks who are most likely to reoffend and have those highest level risk and needs. So this is the slide I showed previously, but this is what the Section 21 asks you all to consider today. So that you should evaluate a policy for people on probation earning 1 day of credit towards their suspended sentence for each day they serve in the community without a violation. And that the working group should think through how to implement this policy without impacting probation term or suspended sentence lengths, whether this credit should apply to both the maximum and minimum suspended sentences, whether the credit accrual equal to the imposed statutory maximum minimum term should result in discharge, whether misdemeanor probation terms should be limited to 2 years, or if the court should have the discretion to impose a longer sentence. And then also asks you all to consider any additional options for early discharge from probation, including options modeled after Vermont's current midpoint review process. So that's the statutory discussion that's being set up. I'd like to kick off the discussion. Things that I think would be helpful to start this is how different stakeholders who are on this call and working in this system characterize the problem that the probation earned credit policy would solve. So I know that there's been folks from prosecutors, defense attorneys, DOC staff, the Attorney General's office, who have been thinking a lot about this and might like to speak up and help the group understand where they're coming from around this policy. making sure that the working group has enough, knows enough about the underlying need and challenges to recommend a particular policy structure? Do you all feel like you have what you need right now? And then also, is there throwing out there in kind of this bucket of considering additional policy options? Is there a way to actually strengthen your existing policies to better help people succeed on probation and limit incarceration for technical violations? So just a reminder that you do all have stuff already on the books, although we don't really have the data to tell you right now how successful it is. And do you want to consider building off something that's already on the books and already exists? So with that, I am going to stop sharing my screen unless folks want these discussion questions up. But I think it will be helpful for everyone to be able to see each other. And I hope
You're muted
yourself.
I don't know how that happened, but I believe I'm not sharing anymore. And I was just hoping that folks would speak up and kick us off in starting this conversation.
Well, since the Senate started this mess of the probation issue, and then in conference committee, or I guess it wasn't a conference, the language they have in front of us, I'm willing to look at anything. We're not stuck with some particular way, but it seems like the current system doesn't have enough automatic. And what got us in the Senate side was the fact that most people end up violating conditions of probation within the first 6 months or so. And people that make it a year or 2 years and then have a step back would frequently get themselves violated on probation, and it became a problem. So I thought looking at Montana would be a good start, or at least from what I saw in your slide that I looked at regarding Montana. But I also wonder how we could strengthen what is already in law regarding the discharge. The one thing I'm concerned with, after Karen mentioned that the risk assessment doesn't cover domestic violence, I'd be concerned, because that's probably the #1 crime in Vermont. If I was to pick one where a crime of violence where we see a frequent use of the criminal justice system.
Senator, I'm actually going to touch on that a little bit later.
Good.
In terms of what current assessment can do and what's missing around domestic violence assessment. So
yeah, but
I will.
It seems like the current system allowing the probation officer to make recommendations on discharge is not very. It may or may not be used depending upon that probation officer's own experience, and I'm not that familiar with how many actually end up getting released from probation. I think there was testimony that it's not used that often, but it was pre-COVID when we had our testimony, and I'm not that clear on what it was. If that's a start from me anyway, I would say the Senate is completely open to any idea, as long as we address the length of time some people stay on probation and really haven't had a violation and then take one step back and get really messed up in the system.
So Sarah, this is Dale Crook from Department of Corrections. We do a risk assessment on all domestic violence offenders called the DVISR that does indicate domestic risk. And we do use that in how we supervise. We use that in conjunction with the ORAS, which is a general risk and needs assessment. And we usually supervise the domestic violence offender on whichever risk assessment they score the highest on. So an individual could be with a DVISR a high risk for domestic violence, but has a low risk needs score on the ORAS, we would supervise him as a high risk offender. So we do risk assessments. I think it may be helpful to the probation credit kind of came from a conversation that we had, that corrections had with CSG pre-COVID years ago now, it seems. And the rationale for the proposal that came from us was the way that the department supervises now. We supervise based on risk and needs of the offender. So high risk offenders get supervised more intensely than low risk offenders. The legal status that we supervise on is really irrelevant to the level of intensity of our supervision. So an individual on furlough, probation, or parole that scores high risk will be supervised as a high risk offender. The difference is for parole and furlough, that offender is earning time off his or her sentence. Someone on probation is not. And the way that probation can work is it can actually keep individuals connected with the Department of Corrections a lot longer than needed. So an individual could be on for 1 or 2 or 3 years on probation, whatever reason, get probation revoked, and they start at day 1 of their sentence. So they had a 1 to 3 year suspended sentence with a 3-year term. They could be on probation for 3 years. They may not complete all their conditions of supervision. It gets revoked. They go back and they start their sentence from day 1. So they still have 1 to 3 years left to serve as a sentenced offender. So they will not be out of corrections custody for a 6-year period of time. So that was the logic behind it. I know it creates concerns and issues for the sentencing process. And I think, to be honest, I think that the underlying, if this was something to be, really looked into, the sentencing structure would have to change because it's built on a different system. So you'd have to look at it at a different way than what is currently. You can't change the system dramatically and expect to do things the old way and have it work out. I don't think that's reasonable. But I do really agree that this is just part of a change. I do agree with David Demora that upfront information is going to drive us a lot better on how to put people on community supervision. So I think that's going to drive it. It's easier to have someone on low risk on probation and not really worry about what happens because they're going to be successful. But I think a lot of that is information up front, and a lot of it is going to drive the conditions of supervision based on those risk and needs assessments. So I think that I don't think it's going to be, you can't talk about probation without really talking about the conditions of supervision that's going to make someone successful and reduce their risk to reoffend or set them up for failure. I'll stop there. And I know there's a lot of people have thoughts and opinions about that. I'm more than happy to clarify or continue. So.
This is Alice Emmons. When this legislation came before our committee on the House side, we were supportive of the proposal for earned time or having time for credit for time served under probation. As it started working through the process through other committees, there was some pushback from other entities about credit for time on probation that would be accrued towards your underlying sentence. So I agree with what Dale Crook just said, that you really have to look at the foundation of our sentencing if you're going to make a change like this. But I wanted to be real clear that my committee on the House side really did support a proposal to really look at credit for time served on probation and how that would play into your minimum maximum. But as it started working through the process on the House side, there was pushback from some other entities, and that's why it ended up not going forward.
might jump in quickly if you don't mind. Just because we were one of those, the state's attorneys were one of those entities that were kind of along the same lines, or were they very strongly supported incentive-based program, one that gives kind of clear parameters and gives the probationer something to work towards. One thing that Sarah said, which is really important, is that for at least misdemeanors, the probationary term almost always exceeds the underlying incarcerative sentence. So that state's attorneys just wanted to note that if, for instance, if someone is got a 5 to 180 day incarcerative sentence, all suspended except for 1 year of probation in order to complete programming, after 180 days, there's no longer an incarcerated. And so a probationer would actually be incentivized, encouraged to violate, because then there's no further involvement in the criminal justice system once there's no longer an incarcerative portion underlying the probationary sentence. So again, it just speaks to the fact that if you're going to implement a program like this, looking at the kind of entire sentencing structure would be critical. So that was the state's attorney's main objection to this. But we also had a counter proposal about kind of, look at that time period when violations are likely to occur and when they're less likely to occur. I think for misdemeanors, it was usually around 8 months, and just set a mandatory review at that period and see how people are doing, see how closely they've come to completing their programming, and either have a petition to the court to either eliminate the remainder of the probationary sentence or to modify it. So that was our counter proposal.
So this is Dale Crook again from Corrections. We do have on statute and a rule a midpoint review for probation. And what that is at the month prior to the middle of the probation term. So a 2-year term, it would be at 11 months, 1 year less than the middle term. The Department of Corrections probation parole officers has to review the probation case. If the offender has completed all their conditions of supervision, we shall submit a discharge for probation to the court. If they've completed some of them, we can request a reduction in term. And then if they've, hasn't really done anything, we continue with probation. But the department, it's a rule, we have to do that. My opinion, I think where the breakdown happens is the rest of the criminal justice system might not accept that review. We've heard from state's attorneys that I said a 2-year term, we expect a 2-year sentence. So that's where the breakdown happens. We have, and I believe that goes for judges as well. So the department still has to do this process, even if we know the court that we're sending them to will not honor them or will not even review them. So that's one of the issues. I agree with Pepper. I think that could be an option as well. When you have different courts, and when I mean courts, I don't mean the judges, but the court county processes, having different standards of how to review probation discharges based on the term, that does kind of still, it still fuels the justice geographic disparities that we have, because some counties will honor it and other counties will not. So that's one of the concerns that we have with midpoint review, is that it's just because we can submit a discharge because the offender has done everything that is required of them doesn't mean that it will be honored on the receiving end.
Well, this is Dick Sears again, and I just am reminded that this was actually Mike Touchette when he was commissioner first David Scher from the Attorney General's office, and I had a discussion about it. That's how it actually got in there, to give a credit, because what Dale was just saying, that there's geographic disparities on if and when these recommendations are taken. So again, I'm completely open. I actually am thinking about introducing something on the Montana profile or something similar to that, and seeing where that takes us.
So I have a question, if I could. So the midpoint review is just a recommendation that then goes to the prosecutor, the state's attorneys, and the court? Is that what happens?
Yes, it's a discharge request from probation from the probation officer. The Department of Corrections can actually recommend a discharge at any point during supervision. I guess technically we could request a discharge from day one. Doesn't mean anyone's going to honor it. But we can request a discharge. If we do not request a discharge for supervision, the case or the probation expires at the end of the term date. And on the probation order, if it's not indefinite, there will be a term date set on the probation order, and that's when supervision ends.
So there's some way that, maybe this is a dumb question, I mean, can that recommendation instead either be made binding, or there's an assumption that it is correct? Or, I mean, if that's where the breakdown or problem is, why not focus on that as perhaps a relatively straightforward fix?
Now, I would agree with that, but you are now putting additional authority to the Department of Corrections, which would be a discussion, because now we would have the authority to end someone's supervision. I would think most people would probably argue that we would look to extend people's supervision, but that's not really the case. This is really, I think that is a good suggestion that is worth a conversation, but with the understanding that it does put more power or authority to the Department of Corrections to make discharges for a case that comes from the court. So,
but it doesn't even have to be binding. It could be something less than that, that a rebuttable presumption or some sort of higher standard that a prosecutor needs to overcome to not follow that recommendation. It seems like it's worth looking into.
It's a motion to the sentencing court, right? I mean, the prosecutor can obviously stipulate to it or oppose it, but ultimately it's in the discretion of the sentencing court whether to accept that recommendation from the midpoint review, just to be clear on that, right?
I do believe it is the court's decision, but I do believe most of them go through the state's attorney's office. You probably would need to maybe talk to one of the courts, but sometimes the judges operate and the courts operate a little differently between all the different courts, and they require some require paperwork to go through the state's attorney before it goes to the court to see if there's an objection. Sometimes it goes to the court and then they send it to the state's attorney to see if there's an objection. So sometimes depending on the court and the probation office, there's different filing mechanisms.
But the rule does say that the petition is to the court. If you look at what the midpoint review says. So to your point, Pepper.
Like, my only point there is that if the state's attorney denied one of these midpoint review recommendations, that wouldn't be a final determination, that it would still be on the judge.
So right. My experience was that the discharge recommendation would come in from the Department of Corrections, and at least the courts that I was sitting in, if it wasn't clear that the state's attorney had either been notified or consulted, we would ask the state's attorney to weigh in on whether they are opposed to the discharge or not, and depending on the response, schedule a hearing. And that practice may not be consistent throughout the state, but that's certainly been my experience, which I think is consistent with what Dale was saying. I'll add this. Pepper mentioned the hearing review, and I will be the first one to say that I'm loath to ask for, further hearings in court. But and maybe Sarah can get some data for us. I think Vermont is one of the few states that does not have review of probation by the court. The only time the court sees issues relating to probation is when a violation is filed or a discharge is requested, but we don't have any, there's nothing in the statute that allows us to review probation, let's say 6 months in, just to see how an individual is doing. Are they complying with counseling requirements? And I don't know if that's what Pepper had in mind. That may be worth exploring to try to avoid the violations. My experience again has been that there may be a series of events that occur over a 6 to 9 month period, and by the time the court gets the first violation, there's actually perhaps been violations ongoing that the department is trying to correct. And I'll throw this out, and it hasn't been discussed before, and I don't know how popular it would be, but if you remember one of the early slides that Sarah provided, it talked about the options that are available to the court and to the parties when a violation is filed. You can revoke, you can modify the conditions, or you can continue on the same conditions, generally speaking. Again, my experience is that, let's go back to the original sentence. 99%, I think, is the number that Sarah's group came up with. 99% of the cases are settled, are resolved through plea agreements, meaning that these folks that are going on probation are coming in because the state and the defense have reached an agreement to put the person on probation. To what extent the Department of Corrections is involved in advising or suggesting to the state's attorney, or both parties for that matter, whether probation is appropriate for that individual. Clearly, some cases are resolved with a probationary sentence to avoid a trial. The individual defendant wants to avoid incarceration. And so sometimes a probation sentence comes in that, although the person is put on probation initially, they're looking at a high minimum sentence. And so when a violation occurs, and let's assume that we're at the level of revocation, we're sometimes looking at a sentence that's already baked into the process. We have no way of saying whether that sentence is appropriate at that time because it's been by agreement. There have certainly been cases that come into the court for violations, for possible revocation, where the parties agree that what the person needs is not necessarily to go to jail or to serve a minimum sentence, but rather they need a higher level of supervision that probation can't provide. And that is, can a probationary sentence be amended at some point to allow the person to go on a furlough status? I don't know what corrections or state's attorneys or the defenders think of that approach, but there's certainly been a number of times when all the parties agreed that's what was necessary for this person. But our statutory framework doesn't allow us to modify those sentences. So I guess I throw that out there as just, when we're looking at the probation system, is there another approach entirely that we could use?
This is David. I had a response to the comments that are responsive actually both to what Judge Gerson just said and also to what Pepper said a few minutes ago. One thing I wanted to note was that the S338, I believe it was, as it passed out of the Senate, had addressed the state's attorney's concern, which was that the credit was going to accrue only to the minimum of the sentence. So even if they were on probation successfully without violation for quite a while, it was not the case that they would have had no sort of sentencing liability left and they could just do whatever they wanted. The maximum would still have been there. It's just that there would have been a zero minimum. So I don't think that the state's attorney's concern was still relevant after the Senate, in the Senate's final version. I think that had already been taken care of. And that also brings us right back to Judge Gerson's point that he just made, which is that would in fact be a way of transitioning a probationary sentence to a furlough sentence, because if there is a violation, the person, let's say they've run through their minimum, they would now have a zero minimum. They could be sentenced under that, and they would effectively be on furlough at that point, the way our system works. So I think that sort of that system would actually address both points, both the state's attorney's concern and Judge Gerson's idea about putting transition to furlough. The other thing I wanted to point out was that I think you look at slide 37, I believe it is, of the presentation. I think that is the concern that we're trying to address. As Senator Sears mentioned, we had a discussion about this, and unless I'm misreading that slide, which is entirely possible, it does seem to indicate that there is an issue with probation violators ending up in prison for a longer periods of time than people who violate on parole or furlough. And that's really what the issue we're trying to address here, which is let's make this more even and more fair. Theoretically, people on probation are under less supervision because they don't need to, there isn't, at least in theory, there isn't as much of a concern around having super tight supervision. So why are they then ending up in jail for longer periods of time on a violation? I'm not sure that makes a lot of sense. And I think the point was, let's even this out. And one of the ways to even it out is to treat, to give people the ability to have shorter underlying sentences as long as they are behaving appropriately. And I think that I think it's slide 51 is a really good summary of the kinds of policy issues we're trying to address. And I think the Senate's version of S338 did achieve two of those pretty well, which was the sort of top two on slide 51, decrease the length of incarceration for people who are successful on probation for a period and then revoke. And also it provided people on probation an increased incentive for behavior change. I think that we already have some policy that gets at the decreasing probation term, which in terms of the midpoint review, but I'm certainly open to suggestions for how that could be made stronger or made better. And I also certainly think we need to address the probation resources, focusing on those most likely to reoffend. There's a slide that clearly shows higher risk people do in fact reoffend more, and I think we need to have a better match between resources and risk, and that's something we'd also be open to discussing for sure. I think that's an important goal that S338 did not really address, at least in terms of that probation piece. So anyway, that's just a summary, I think, of where we were coming from on this, the problem that we had seen, and I think the data now shows that slide 37 shows that was not just an anecdotal concern, but one that was backed by data, and one that I still think we should address, and that I think we have a model to move forward on it. But again, very open to additional ideas.
So 2 points on that. We supervise based on risk and legal, regardless of legal status. So the only change in supervision is basically who resolves the violations and the conditions of supervision. On the second part, having the credit just off the minimum kind of defeats the purpose of the proposal, because it still keeps an individual on supervision with the Department of Corrections one way or the other for an extended period of time. So to have someone revoked on a community supervision status of probation, just to be eligible to go on another community supervision status, which they already proved was not a successful process for them on furlough, kind of defeats the purpose of the original proposal with the midpoint or with the credit for probation.
that's a fair point, and I want to be clear that the technical aspects of this, I wouldn't say we're particularly wedded to, but I do think we should remain open to a system that would lower incarcerative liability for probationers, and I think the data shows that that would have a real effect on our system.
Okay, Sarah, is this a good point to take a 10-minute break?
Yeah, I think if folks are up for that and need to stretch their legs and perhaps get a snack, then that's great. When we come back, we do have David Demora presenting on behavioral health and risk and needs assessment and assessment information. Unless folks really want to continue this conversation, but at least for folks who have their camera on, I'm certainly seeing some nodding heads for a break.
Okay. All right, let's take a quick 10 minutes then. Thanks. David, I see you're back.
Yes, sir.
So let's give it another minute, and then I think we ought to get started. Okay.
Sounds good.
Okay. Okay. I hope most people are back. I think it's been about 10 minutes. I'm sorry, I wasn't actually timing it, but it's pretty close. I did not mean to cut off any conversation. So if there are additional comments, if you would hang on to them, and we'll open it up again at the end of the meeting. So I'm going to turn to David Demora now. David, would you take over, please?
Certainly. Thank you very much, and good morning, folks. For those of you that I may not have met, my name is David Demora, the Senior Advisor here at the Council of State Governments Justice Center, where I work on a variety of projects over the years. I tend to work at the intersection of behavioral health and criminal justice, although I have done a lot of work with issues related to violent offenders and risk and needs assessment as well over the years. And I'm going to pick up now and talk a bit about some of the behavioral health findings and recommendations, again, from phase one, though I'll add some color commentary, having spent more time in Vermont or with Vermont since then. And as I believe I told folks that I've testified before, spoken with before, if I do my job well, I'll probably annoy most of you at least once as I go through this presentation and we look at the various issues that there are. I'm going to share my screen now, and hopefully that's going to work. So let's see how that goes. You should now have in front of you the slide 54. Sarah, is it there? Just to check.
It is, David, but it's not in presentation mode yet.
So let's get that there. And now we are in presentation mode. Okay. So let's sort of start with the good news, if you will, which is that nationally, Vermont stands out for its low ratio of residents to behavioral health care providers, which is very nice. And I'm going to just move one of my screens here so I can see everything. When you look at this chart, you can see that you have roughly 300 or fewer people per behavioral health care provider, which is nice. You are right there at the top. There's only a couple of states that have lower ratios than you do, and many states, as you can see, that have higher ratios. And so on the good news, if you will, is that you do have a decent ratio. The problem, of course, becomes, as you all know, that that depends on where you live in the state. And in some places, right, that's the average for the state, but in some places you're going to have way fewer folks per provider, and in others it's going to be more problematic just because of the nature of the state and the difference between the urban and rural areas across the state. When we talk about addressing the behavioral health needs of clients during community supervision, we often talk about it badly, and this is one of the things that I have seen as problematic in Vermont, is the disjointed response between the mental health, substance use, and correctional systems. That is not an insult to any of the systems. The systems are all very good systems. No system is perfect, but they are among the better systems that I have seen across the country. My issue has to do with there needs to be improved coordination and collaboration between the systems, particularly once people are returned to the community. There needs to be improved coordination and communication between the systems from the time somebody enters into the criminal justice system, throughout their time in corrections, inside if they're incarcerated, and their return to the community. One of the things that I have seen as I sat in on court hearings back when I could do that, and in the last few months when I have sat in on parole hearings, are the overwhelming number of individuals with mental health and or substance use needs, and a varied understanding of those needs. Some of the folks that I was watching looking at this, whether these were officers or caseworkers or parole folks, parole board folks, some of them had a clear understanding of these underlying issues and others did not. And there is a tendency to use furlough or intensive supervision as the answer to the problems. And I understand why. If you're concerned about somebody in the community and they are particularly at risk of hurting themselves or causing great damage because of their substance use, and you do not have the appropriate options available for them, then that's fully understandable that one wants to do something to make them safe. The problem becomes that when they need a residential bed or they need an IOP, but they end up with intensive supervision or in some cases an incarceration, it's the wrong response for the right reason, if that makes any sense. This particular chart here talks about impact in terms of lowering recidivism when we have behavioral health needs. And what the, excuse me, and what the data basically tells us is that, yeah, there's a role for intensive supervision. There's a role for intensive supervision that is trained supervision, that is focused on the kinds of things that parole and probation officers focus on, those who've been trained, for example, in ethics as your supervision officers have been, but also the issue of them needing to be involved in the appropriate treatment-oriented programs. That might be a combination of correctional intervention programming, like cognitive programming, or it might be drug treatment, or it might be mental health treatment, or it might be some combination, or what we would call integrated treatment. And that is the great challenge for Vermont. You have a lot of high risk and needs individuals left in your system. You've done a wonderful job of getting many of the lower risk and needs folks out of your system. That has left you with the most difficult, and when I say difficult, what I mean is the most complex individuals. They require an integrated response that at this point, Vermont is still struggling to perfect. When we talk about addressing that overabundance of folks with behavioral health needs that are in the criminal justice system, we really talk about implementing a comprehensive approach for working with that population. And so there's these sort of four areas that we talk about and that we look at and that we talked about in phase one. One is improving the identification of people who have behavioral health needs in the criminal justice system. Two is ensuring access to a comprehensive array of treatment and support services, both while incarcerated and in the community. Third is prioritizing effective correctional interventions, the cognitive behavioral interventions, thinking for a change, and other kinds of programs of that sort. For those that are at the highest risk of recidivism, but also ensuring that people with behavioral health needs receive the behavioral health treatment they need, regardless of the criminogenic risk level. Just because one is low criminogenic risk, meaning just because one doesn't have some of the antisocial factors that increase their criminality, it doesn't mean that they may not have significant mental health and most specifically substance use problems that will contribute to their failure. We used to think that substance use by itself was not that strong a variable in terms of failure. And what we now know from the work of Faye Taxman and others over the last decade is that even those individuals who do not score high in terms of general criminal risk, the antisocial factors, have a higher failure rate on supervision because of their substance use. And so we need to attack that regardless of level of criminogenic risk. And then the fourth is strengthening the collaboration and training between behavioral health and criminal justice agencies and local levels. And this is an issue across the country, just to be clear. I talk to mental health departments and they very often say, no, that's DOC's issue. But it's only partly DOC's issue. I talk to DOCs and they say, well, we're dealing with this. Well, why does the DOC have to deal with all of that? I talk to community providers and they say, well, yeah, we get this referral, but we don't get this other information that we need. So it's a common problem. Some of the problems that Vermont is facing are certainly not unique to Vermont. Some of them are exacerbated just because of the variances in how things happen regionally in terms of your population, et cetera. And you certainly have done a lot of very good things to ameliorate what you can. For example, DOC does work to identify people's behavioral health needs. They look at their substance use issues, they look at their mental illness issues. They do this at various points throughout the correction system. When the person's detained pre-trial, they're initially screened for substance use and mental health needs by the DOC contractor, a healthcare contractor. Anyone who's sentenced to a period of incarceration is also screened and based on the results may receive a follow-up clinical assessment by the healthcare contractor. People who begin furlough or parole or have a split probation sentence receive the ORAS-ST, which is the community supervision tool. So that's the risk and needs assessment tool for people that are going to be on community supervision. The ORAS, or Ohio Risk Assessment System, is a system of several tools that can be used at different points throughout somebody's involvement in the criminal justice system. One of the things that is somewhat problematic from our perspective is that people that are sentenced straight to probation do not receive a mental health screen. And I sat in more than a couple of hearings where, as a clinician, it was very obvious to me that the people before the judge had some significant mental health issues, but that wasn't being discussed at that point. Now, it may have been discussed later. It may have been discussed at another point. I don't know that. But what I know is that at that decision-making moment, that information didn't appear to be available to folks as they were talking. And I should also say that I sat in hearings in different parts of the state, and how some of that was approached was different depending on where I was in those different parts of the state. People do need to be screened for mental health and substance use needs, really at all stages of the criminal justice system, right from entry. We know now that many of your law enforcement folks are constantly being called to calls that are related to behavioral health and substance use, and often being called as law enforcement when in fact they need other supports to be helping them in terms of responding. And you have some of those programs, but you still have many situations where law enforcement is in a position of sort of unilaterally attempting to figure out what to do and not having very many options, right? Not having a residential bed, not having a diagnostic center, not having those kinds of things. They have no choice but to default to bringing that person to jail, at least for the moment. And that's understandable, but it creates a cycle of a problem that arguably then keeps increasing as that individual stays in the system. Many people with substance use and mental health issues, their initial contact with the system often is a combination of the substance use and mental health and criminal behavior combination. That criminal behavior is often resultant from the mental health or substance use issues, or at least it's parallel to it. And so it is, frankly, some folks say, well, no, if we just did the mental health problem, or if we just solved the substance use problem, then none of those folks would end up coming into contact with the criminal justice system. The evidence actually doesn't support that for all of those folks. It does for a significant number. What is really problematic is that once those individuals do get into the system, is that generally speaking, the system tends to excuse me, somebody's just sent me a request. Let's see if I can approve that. Okay. problem is that when folks with behavioral health needs get into the criminal justice system, very often they end up getting trapped in the system because the system is unable to respond appropriately to those needs. And so they respond perhaps to the criminal behavior part, but it's not that effective because they're not able to respond to those other issues that get in the way of the person being successful. And we thought for a lot of years that because they weren't directly related to the person's recidivism, meaning because they weren't those central 8 criminal needs, that perhaps they weren't relevant. And we've learned the hard way that they're very relevant. And that when we have people with a number of criminal need factors, the higher risk individuals Dale was mentioning, who also have those substance use / mental health issues or some combination, that those factors will end up causing that individual to fail no matter how high the quality of the criminogenic risk response is, no matter how good that treatment piece is. And so we see a lot of people fail, not because we aren't attempting to respond, but because the right combinations of responses are not provided or are not available, typically, for many of them. And I now have a pen, so excuse me, I was, okay. Forgive me, folks, I'd received a request about annotating and it ended up creating a problem for my being able to switch the slides, so I had to fix that. Supervision staff, in terms of DOC, rely on reentry case plans to inform their understanding of a person's mental health and substance use needs. There can be sometimes a disconnect between community providers and supervision officers. Again, not all of the time, and I saw a lot of really good stuff when I was going around during that first phase and saw a lot of really good officers doing really good work. Supervision staff have access to behavioral health information within the reentry case plans to help them understand the behavioral health needs of folks that are moving from incarceration to supervision. Case plans for folks who don't receive MAT or medication-assisted treatment, or who are not identified as having SMI or severe mental illness, may not always reflect other types of behavioral health needs. And I saw that in some of the summaries, for example, that I was reviewing the parole sees, that they didn't necessarily reflect some of those other needs that individual had because they didn't rise to a certain level. Community providers reported some inconsistencies related to facility handoffs in terms of MAT, depending on, again, what part of the state we were talking about. Behavioral health information sharing between DOC, the healthcare contractor, the facility reentry caseworkers and the supervision officers, and the community-based providers for care coordination and care management, we found to be inconsistent, which increased the difficulty of coordinated comprehensive case plans. And in fact, we'll be having a number of meetings with all of the different agencies that are under AHS's umbrella to really look at that. And that there's a report due back to the legislature in early December. But it will be important to have all those agencies involved in those meetings and to really look at what folks have already been able to determine as appropriate ways to improve or increase information sharing among the appropriate entities, and to do so obviously in the appropriate and legal way. There tends to be less behavioral health information available to inform supervision conditions for folks who are sentenced straight to probation compared to people on furlough or parole. PSIs are rarely conducted for those folks, pre-sentence investigations. And the SLA, their initial screener, doesn't include mental health screening questions. And so I'll come back to that issue. One of the reasons that PSIs don't happen is that PSIs in the traditional sense are very time consuming, and there's very understandable reasons why they don't. And I don't want to, early on, we were talking about, frankly, whether or not those needed to be done more widely. And we understand that from a resource perspective, increasing that type of tool is just simply not possible. We would argue that there may be a middle road that can provide some additional information that doesn't take that kind of time and intense work on the part of the officer. There are lots of things in a PSI that to look at this issue of mental health need, it just is not required. And so we'll talk a little bit about that as well. People with behavioral health needs in the criminal justice system often require access to an array of providers and services. And as you can see in this wheel, that isn't just the traditional services, right? When we talk about issues of transportation, it's a major issue. Supported housing is a major issue. In many cases, and this happens in Vermont too, even when there's available housing, it's the wrong housing for the people that you have. And so while you do have a number of different housing services available, many of them have sets of rules that just don't match the needs of the clients. And so part of what needs to be looked at is what is it that we are putting out in terms of resources and dollars for services, and do those services meet the needs of the clients that we have to provide the most evidence-based service? And whether that's looking at mental health care, supported housing, the type of supervision that's being utilized, because there are differences depending on whether people are on furlough or people are on probation or parole supervision. Those officers behave differently. And so how do you have greater consistency in terms of that? Whatever you're talking about in terms of this wheel, there needs to be a clear examination of, is what we're doing, no matter how well we're doing it, is what we're doing relevant to meet the needs of the individuals that we are serving in order to lower recidivism? And if the answer is no, it's not doing that, then it's not that people are bad or not doing their best. It's that doing one's best within a construct that's the wrong construct still doesn't get you the outcome that you need. And so how does one revisit these different things to make sure that the processes match for the individuals that we are the highest need, highest risk, most complex, and typically have multiple problems and issues? Vermont has indeed done some really cool things around this. And again, one of the things that I said this before, Vermont has done so many things that you don't have that much, if any, low-hanging fruit. And so when we talk about things to do, we're always talking about these sort of bigger things because you've done so many of the other things that so many other states haven't touched yet. And I don't want to forget that as I keep talking about what needs to happen or how things can be improved. What you're building on is so much more than what we often see in so many states. You have built critical service and support infrastructures that provide statewide assistance in a variety of innovative ways. They can be strengthened, they can be expanded. They're not perfect, but boy, they are really, really very nicely done to the degree that you've been able to get those in place. MAT, for example, medication-assisted treatment, is widely available both in the community and in the DOC facilities as part of your statewide hub and spoke model, which quite frankly is a national model. Particularly the work that DOC has done in terms of providing MAT within its facilities, I kid you not, it is a national model, especially when we're talking about the issue of people who are struggling with opioid disorder. DOC has amended its contract with the healthcare contractor to a spoke level of care as well. And based on conversation with the DOC and the providers, there are strong wraparound services for the SMI, the severe mentally ill population in the community. Having said that, counseling is offered to clients at hubs and spokes, and DOC offers medical supports such as MAT inside the facilities. But due to resource challenges and workforce challenges, DOC is limited in its ability to offer clinical supports that align with the best practices. So MAT is happening, but there's not as much clinical or therapeutic or counseling intervention as we might want to see across the board for those individuals who are incarcerated. And again, it's not because DOC doesn't want to do that. It's because when we look at the issue of the resources that are available, of the type of staff needed that are available, there are shortages. Many people assessing MAT at the hubs and spokes have significant unmet housing needs, and the expertise and capacity to refer clients to housing resources varies, and not surprisingly, across the state, depending on where one looks. There is opportunity and need to further strengthen and expand access to the services to have a more comprehensive and consistent impact across communities and across people. There are innovative community models to support law enforcement's response, for example, to crisis calls that can inform a statewide approach, including the Howard Center's outreach teams, Brattleboro's Project Care, and really law enforcement needs that support. Everywhere I look across the country, nothing's perfect, nobody's perfect. There are genuine concerns about how some situations are occurring in law enforcement, and that needs to be examined. The other side of that is that law enforcement is constantly called on to do things that they shouldn't have to deal with alone. That the answer is not simply to call law enforcement and they'll solve it. It really does require support, them having additional supports in order to meet the needs of these individuals who have significant mental health or substance use needs. Vermont has peer recovery networks across the state and embedded peer recovery coaches in emergency rooms. And there's a voluntary DOC peer recovery coach service that's called Open Airs. Again, all very cool things. As I said already, law enforcement agencies, however, have varied access to community-based resources when responding to behavioral health crisis calls. Due to resource and workforce challenges, DOC mental health treatment is prioritized for the severely mentally ill population. And again, one can understand that. Why is that problematic? Because if we have somebody with high criminogenic need, meaning they need the cognitive programming in order to lower their recidivism, and they don't have a severe mental illness, but they have ongoing anxiety disorder, ongoing depression, ongoing several other possible kinds of issues, that will get in the way of them effectively benefiting from this kind of programming we know would make a difference around their criminality. And so it's of a piece when we talk about these things. It all relates to how do we increase the success rate of the individuals, or more specifically lower and also lower the recidivism rate of those individuals. There's limited co-occurring disorder treatment across the state for folks who are incarcerated or on supervision. And as we've already talked about, transportation is a significant access barrier for people across the state. And obviously, again, particularly in the more rural areas, but in general, it is a barrier for them. So case planning really needs to be informed by a person's unique criminogenic risk and behavioral health needs. Back in 2012, Fred Osher and myself and some of our staff pulled together about 35 or 40 specialists from across the country in terms of behavioral health, meaning substance use, mental health, and criminogenic risk. And we developed a model looking at this issue of folks with criminogenic risk, substance use need, and mental health or mental illness need. And we developed this model that basically said folks with low crim risk still need the substance use and mental health supports, but they don't necessarily need to be provided through the correctional system. Don't use corrections, don't violate somebody on probation who's low risk because they need mental health treatment and put them in prison or on furlough. That makes no sense. They do need to get to a community provider. You do want to provide those supports, but you don't want to waste precious supervision resources on some people who are low criminogenic risk. For those folks that are the high or medium high criminogenic risk, if they have high substance use and mental health needs, that's particularly where you need this integrated response, where you need to have your supervision agency, your mental health agency, and your substance use agency working together, not just inside through contracted services, but throughout the community to assure that there is a coordinated collaborative response to folks with these needs. If I were redoing this today, I would add 2 other lines. One would be for domestic violence and one would be for sexual violence. We continue to underestimate domestic violence and the responses needed, and we continue to overestimate the recidivism risk when it comes to sexual violence. And we have developed responses to these that are, in both cases, not as fully based on the science as they should be. Further, I consistently see in all correctional systems many people who have underlying domestic violence and or sexual violence issues who do not get evaluated for those issues because their ultimate conviction was not specifically labeled as such. And there are lots of reasons for that, and very good reasons in many cases. That's not my point. My point is that it actually is an additional burden that corrections departments and supervision departments and officers have to pay attention to. They have to consider the evaluations that they're doing of these folks based not just on the crime of conviction, but on the underlying behaviors that that individual may have been involved in that led to whatever the particular conviction is that they end up having. Though there are treatment case planning policies in place, people are inconsistently connected to community-based treatment. According to and by the way, again, obviously this was all pre-COVID that this discussion was happening in phase 1. We know that during this COVID phase, there are lots of other challenges and issues, and we don't mean to ignore those, but this is what we saw in our initial phase 1 work when we were all in the community, if you will. According to DOC policy, which indeed DOC is working mightily in revising a number of their policies at the moment, to be clear. According to DOC policy at the time, case plans for people on community supervision are to be informed by behavioral health information that's identified by screeners and assessments. Some DOC supervision officers clearly had built strong relationships with local services. They leveraged those connections incredibly to help clients connect with available services. I saw officers getting them housing. I saw them connecting them with landlords. I saw them driving to different places. I saw them bringing them to the MAT. I saw all kinds of things happening that were very positive, and officers doing incredible jobs, just to be clear. At the same time, despite the policy, case plans are not always informed by the behavioral health needs of the client due to resource constraints or sometimes court-ordered stipulations, frankly, or limited service availability. There are challenges to sharing the relevant behavioral health information and coordinating the care between supervision officers and community providers, which can negatively impact overall case planning and subsequent treatment and programming referrals. And I saw that both ways. I saw the community providers not always getting information that was relevant, and I saw officers having difficulty getting the information from the providers that providers should have been providing them, no pun intended. Due to funding limitations and challenges in care coordination, people with mental health needs that don't rise to the level of severe mental illness tend to be underconnected to the continuum of care that are offered by the designated agencies for mental health in the community. And for folks with co-occurring disorders on MAT, there can be a lack of coordination for mental health treatment across the providers and supervision. So while a person may interact with multiple agencies, the agencies themselves are not communicating, coordinating, or collaborating to the degree that they need to be, even though many of those agencies currently are actually under one larger agency, if you will, which is one of the reasons for the meetings that we will be having with folks, is to really help folks think about how to de-silo, right? How to really work more closely together, how to improve on what it is they're already doing, because again, a lot of good things are happening. But right now, the system that folks are interacting with is somewhat fragmented to criminal justice, behavioral health agencies, serving folks, and it is up and down, depending on, again, where in the state, who the particular folks are that are involved, et cetera. We need something more systematic and consistent across the state, between the agencies, among the individuals, to assure the appropriate responses are provided in order to lower recidivism. Now, Vermont has been paying attention to this, of course. You've been expanding your cross-system training, particularly crisis training for law enforcement. Key actors in the criminal justice system, including judges, supervision officers, state's attorneys, have reported to us that the training they received has helped their responses evolve in terms of responding to folks with addictions. They tend to be more thoughtful and less punitive in response to a person that's experiencing relapse. The existing crisis training for law enforcement includes a strong focus on understanding mental illness and administering naloxone, for example, for folks who have overdosed. State police are receiving cross-system training that includes sessions provided by trained clinicians and people with lived experience. Local law enforcement, mental health crisis workers, dispatchers are offered cross-system mental health training by Team 2, which is a Department of Mental Health and Department of Public Safety grant-funded program that's administered by Vermont Care Partners. And crisis training for this, however, crisis training for the state police and local law enforcement, we would argue does not currently include sufficient, or did not at the time currently include sufficient information on substance use and co-occurring disorders. It's a common problem that we see across the country in terms of things tend to fall down at that co-occurring disorder point. And that's very important because so many of the people in the criminal justice system, even though they might be identified primarily under a mental health or substance use issue, have significant co-occurring disorders. So during phase one, we identified two primary areas to improve mental health and substance use services. One is fundamentally the issue of information sharing, providing better information at sentencing to better guide program and treatment supervision planning. And then secondly, addressing gaps in how people within the correction system with behavioral health needs are identified and connected to resources particularly when they are returned to the community. So we recommended that there needed to be additional information provided at sentencing to better guide program and treatment supervision planning. At that time, again, we talked about the issue of PSIs, and I've come to, I think the language of PSI just so automatically makes everyone in the system think about a specific type of report that I'm not sure people can get away from. So let's stop talking about PSIs and say that what our recommendation is that there needs to be better screening and assessment around mental health and substance use upfront prior to sentencing that judges need to always have consistently. Now, depending on where I was, some judges had that, some did not. And the issue here is to make sure that it is consistently available in a timely way for judges as decisions are made across the state and not just in one area or two areas or three areas of the state. The reasoning in terms of providing more information is that it will help inform supervision conditions. When we look at the number of people that fail on probation and we look at the technical violations, it tells us that what that means is that the necessary responses for those individuals are not necessarily happening as consistently as we would hope. And given that stipulations are determined at the court level, we would like to see those improved in some cases to make sure that the appropriate mental health and substance use treatment is ordered and is monitored. I like the judge's idea about how should we be monitoring this to see how people are doing. And we think that that's extremely important. Now, people always say things like, yeah, but the technical violations, there were 2 or 3 or 4 of them. And so calling them technical is sort of underrating them. I don't underrate them. Technical violations can be very serious, but it's a straw man argument. Whether it's 1, 2, 3, or 4, it suggests that we're being ineffective in our responses. And so the question is, are we doing the right responses to lower that? And we'll never get to 0. But we should have targets to lower the number of technical violations, whether we're talking about probation, parole, or furlough for that matter. There should be targets, and that those targets have to be met by improved responses on our part or on the system's part. There are critical gaps in how people within the system with mental health and substance use needs are identified and connected to resources. DOC facilities have worked hard to develop mechanisms for behavioral health screening and assessment, but there's still some gaps for folks that don't reach the level of SMI. And despite the fact that there are the case planning policies aimed at ensuring behavioral health information to guide treatment, there are challenges that in terms of information sharing, which is something you'll hear me say again and again over the course of the coming months. It is so key in terms of getting things moving and getting the appropriate responses, as Dale, I think, was also mentioning. Mental health and substance use counseling resources tend to be somewhat limited within DOC facilities in the community, requiring the department to use a triage approach. And the current cross-system mental health training doesn't adequately focus on training for responding to folks with substance use disorders. And then finally, the issue of appropriate housing remains a challenge. So there are a number of things for us to focus on and to look at over the course of the coming months and years. So we had a number of recommendations: use validated behavioral health screening tools for folks that are sentenced to incarcerated, strengthen the impacts of DOC case managers by establishing an appropriate caseload level, standardize behavioral health and reentry information policy and procedures between DOC and other entities, develop care coordination and case management protocols for executive agencies that serve people with behavioral health needs under DOC custody, and pursue opportunities to expand access to substance use counseling services for people in the criminal justice system who receive MAT inside DOC facilities and within community settings. We also suggest that there be a development of more robust identification and connections for people with mental health and substance use needs. While the CST includes a domain for behavioral health needs, it's not a validated behavioral health screening tool. The SLA tool screens for substance use, but not mental health needs for people on probation. So we want to see some increase in terms of that ability to screen. Due to the information sharing inconsistencies, officers don't always have consistent or comprehensive knowledge of clients' needs, behavioral health needs, and counseling is certainly offered to folks in the community-based hubs and spokes. DOC offers medical supports, but there are some limitations in terms of offering clinical supports. And as evidenced by observing 15 parole hearings, mental health and substance use needs drive many parole revocations. So I'll end with policy changes alone, though, are not enough. Regardless of potential legislative policy changes, there are key areas that need to be focused on. Aligning DOC and the parole board's assessment of and response to supervision violations with evidence-based practices, increasing cross-system training and understanding of mental health and substance use needs to ensure that people on supervision are referred to the services they need to be successful, and increasing community-based resources for people on supervision with criminogenic mental health and substance use issues. Absent these reforms, violation rates will remain high. But by better identifying these three sets of needs of people on supervision and investing appropriately in the right community resources, Vermont can indeed increase supervision success and safely decrease returns to incarceration. And I will stop with that. Because I have gone 10 minutes over what I should have to begin with.
Thanks so much, David. Oh, Chief Justice, I know you might be chiming in, but I want to acknowledge that we're at noon and we have one more slide left. Clearly, we needed a little bit more, a little bit more time. I'm sure folks are going to start hopping off now. But I did just want to, we didn't have a chance to have a more robust discussion. So I'm thinking that for our next step, Chief and working group members, that we'll continue this discussion into the next November 24th meeting to have the probation earned credit discussion. And we were already planning on having more information about the work that David is doing with AHS, DOC, and all the agencies under AHS. So having more opportunity to discuss behavioral health, but it also seems like the working group needs more time to discuss the earned credit policy. And so that we can do that in the November meeting, if that makes sense to everyone.
Sounds good, Sarah.
Great. If there's anything else that people want to lift up before we get off the phone or before we get out of the meeting, please let us know. And also, I'm sure you all know, but the CSG team is available, in the interim. We do talk to some of you on a regular basis, depending on the project and the various different moving pieces. But you know, with a 19-member committee, we may not be able to reach out to everyone all the time. So if there's something that you want us to know about, we really appreciate it. Please, please, please approach us as we think through what the next meeting and the January meeting look like. We value all of your input and think through how to continue facilitating this conversation. So I know that it's not up right now, but you all have the next step slide in your meeting materials where we just outline what we'll be covering in the next meeting and and hope to get your input on the earned credit policy, which I think we need to discuss a bit more in November. Thanks, David. Chief, anything else for us?
I don't think so. Thank you, Sarah. Thank you, David. Thank you very, very much. It's been a very interesting presentation. I think there will be more discussion, and we'll save it for next meeting on November 24, as you say.
Yeah. Apologies everyone for going over, and we'll try to get our pacing a little better in the next meeting. Or we might be having to request some longer meetings for you all. It's a lot of content to cover here.
Thanks a lot, Sarah. And thanks to everybody who joined us this morning. Thank you very much.
Thank you, Chief.
Thanks, Chief Justice.
Thank you.
Thanks, everyone.